Hello again. This is Namrata Notani from the Law Office of Namrata S. Notani PLLC. Today I'm going to talk about citizenship and why that matters and for whom it matters. If you are the person who is creating a will, you should care about what your citizenship is before you start drafting it or before you get somebody to draft it. A lot of times, a lot of questionnaires do not have the citizenship status even as a question, whether you are a US citizen, a green card holder, or just a visa holder. All three of them have different aspects that are important to know of and proceed accordingly. So let's talk about just being a visa holder. So if you are not a green card holder, that is, you're not a permanent resident and you're not a US citizen, and you're just a visa holder, then at that point, you do not have the estate tax exemption that is provided to US citizens or even to green card holders when your children, your loved ones, inherit from you. This exemption at this time is huge. It's like, together with a couple, about close to $24 million. But when you do not have that green card and you do not have that citizenship, you don't get that exemption. That exemption is barely low. So, which basically means that anything over that really low exemption rate is going to be taxed at a very high rate, close to 40%. So there are ways to obviously overcome that when you are inheriting from a person who is not a citizen or a permanent resident, and there are certain trusts that can be created to prevent that kind of tax penalty. So that is for a visa holder. Now let's talk about a green card holder or a permanent resident. A permanent resident is still a US person, still here, still has the work permit, although they're not US citizens, and their children, or they can actually inherit themselves. They can inherit a lot of, close to the 24 million, pretty much the same exemption that the US citizen has. The only thing that is different for a green card holder is that if a US citizen passes away, one of the spouses is a US citizen, and the person who's inheriting is the green card holder, then the marital deduction, which is unlimited in case of a US citizen, is capped at about 60,000, which means that anything over 60,000 gets taxed at about 40% or somewhat there. So that is, again, a huge tax penalty. And again, you need a certain kind of trust to be able to avoid that kind of tax. Now, if you are a green card holder inheriting from another green card holder, it's pretty much the same. You do not have that marital deduction that US citizens have, which is pretty much unlimited. And you pretty much have the same kind of tax bracket as the $60,000. So just understand that whenever you are creating any kind of estate planning, your citizenship status and your visa status matters a lot. Beyond that, let's say you are US citizens and you're creating a will and a trust, it's really important that the people that you appoint as your executor and the trustee have the right citizenship status and the right resident status. Like in the state of Texas, the executor should be a Texas resident. And if they're not, then they have to appoint a resident agent over here, which can get just more complicated and more cumbersome for them. So it's not that it is not possible, but Texas law states, and they want the executor to be a Texas resident. When it comes to a trustee, you would want the trustee to be a US person. And generally you want especially if you have a qualified domestic trust, which is one of the trusts which is created so that the marital deduction issue, can be overcome in permanent residence. Well, that particular kind of trust requires a US citizen trustee and nothing else. So it's really important, again, when you are creating the will and the trust and you're trying to, think about who you want to appoint as your trustee or executor, that you consider their citizenship status and their residence. It's the same with guardians for your children, because you may have a foreign guardian, somebody that's overseas that you would like to finally take permanent custody of your children because you may not have close family close by. And if that is what you have, then you need to make sure that you have temporary guardians, at least appointed over here outside of your will, so that that person can take that temporary custody of the children right away if something does happen to the parents. And then they can wait until the permanent guardian arrives, and they can arrive. Then, if you do have something that is outside of the will that appoints them as permanent guardians, at least they can show that paperwork and try to get a visa based on that, so they can come to this country if need be, and they can have that guardianship proceeding to be able to get that guardianship over your child, so that the child can then be taken back home. But it's really important, again, that you have a temporary guardian at that point, because if you don't have that, your child is going to be in foster care until that entire probate proceeding is taken care of. So it's important, again, to have your guardians to be close by, and hopefully a resident, if nothing else, which means not a permanent resident, but at least, a resident in your community or in your state for sure, so that they can come quickly and take custody of your children in case of an emergency. So that is all I have today for citizenship status and why that matters for not just the people who are creating the will and the trust, but also for the people you're appointing as executors, as trustees, as agents, which you can name agents as well. But again, you want people to be close by and ready to make decisions for you. And so you need to really pay attention to who you're naming as your agents, as your trustees, as your executors, and they're all together called as fiduciaries for you. Well, that's all I have for you, and I'll talk to you again next time. Have a great day.